Good morning. So apart from the issue of customs duties, which is central to the Brexit discussions clearly, the tax impacts of Brexit have been fairly low down the priority list. As Janine will discuss, this is because there are a lot of issues that business are quite frankly more immediately worried about. And often people assume that the EU won't have had many tax effects on the UK because direct tax has been reserved to member states and isn't an EU competency. But actually the EU has had more of an effect on domestic tax policy than is sometimes assumed. Now, that is, there we are. So this slide sets out the basic areas where tax rules have been affected by our membership of the EU and will be affected by Brexit. I'm going to talk about the first three of those topics in a bit more detail. Janine's going to cover the final two, directives and tax treaties. And we obviously had a very interesting discussion about state aid this morning. So if there are any issues about that, we can perhaps leave those to questions in the interest of time. What the tax landscape is going to look like after Brexit, I think, will largely depend on quite how we extricate ourselves from EU law. And so I'm going to start with a brief discussion about the current proposals for repatriating our legislation from the EU to the UK Parliament. Picking up on the general theme of this conference, I think these proposals indicate a direction of travel, but there remain some difficult and unanswered questions. So the proposals are contained in the white paper for the Great Repeal Bill, and its purpose is stated to be to ensure a seamless transition on exit. The idea is that all the rules that we apply the day before exit will be applied the day afterwards, unless and until subsequently changed by Parliament. Now, there will have to be some changes because so much of our law is tied up with our EU membership that it simply won't make sense post-exit. And the plan for that is to mainly do it by secondary legislation. But we'll have to see whether this will survive the efforts of Jeremy Corbyn, who said that he's going to fight the government every step on the way on that one. Apart from this, the main purpose of the bill is going to be to convert into national law any existing EU law which hasn't already required domestic implementation. That's things like EU regulations. And to preserve existing laws that have been made to implement EU obligations. And that's, the example of that is laws that implement EU directives. To me, there's an open question here about what happens if a directive hasn't been fully implemented in the UK. Will the bill operate to apply the directive to fill in any gaps? Or will you just have to interpret the existing UK legislation as it stands? And we'll see that that has relevance in the tax area. The white paper also says that rights in the treaties that can be directly relied on in a court by an individual will continue to be available in UK law, and that the case law of the Court of Justice up to the exit date will have the same status as decisions of our Supreme Court. So once we leave the EU, EU law won't automatically be supreme in the UK as it is now. And the Great Repeal Bill will have to settle exactly what the relationship will be in future between the EU and UK law. And it does this, or proposes to do this, by setting out three different categories of law. The first is law that was enacted pre-exit that derives from EU law. And the implication is that the Great Repeal Bill itself, to the extent that it is converting EU law into UK law, would fall into this category. This type of law will be interpreted in accordance with EU law at the date of exit. The second category is pre-exit law that isn't EU-derived, so that's everything else. The principle here is that where it conflicts with legislation in the first category, the EU-derived legislation will prevail. So this effectively, in national law, preserves the position of supremacy of EU law in relation to pre-exit legislation. And the third category is post-exit legislation, which won't be subject to EU law at all. So this all seems quite logical, but identifying whether or not a law is EU-derived, it seems to me, might not be completely straightforward. For example, if you've got some EU rules that say you can't have certain types of taxes, but you can have others, are rules about those taxes EU-derived or not? The EU rule doesn't require the introduction of the tax, it simply circumscribes it. That said, I think most existing tax legislation, certainly direct tax legislation, would seem to be pre-exit non-EU derived. And the most obvious example of EU derived would be the VAT code, which implements the EU VAT directive. So on customs, this is the one area where we are clearly going to have new legislation. The customs rules in the UK are currently governed by the Union Customs Code, which is directly applicable, and we don't have freestanding rules enabling us to charge customs duties. And the government announced a customs bill in the Queen's speech to enact a standalone customs regime, which will mainly be based on the existing position. So the idea is that at least for those importing from outside the EU, the position shouldn't change significantly. The position for EU imports will obviously depend on the result of Mr. Davis's discussions. VAT is the next topic on the list, and the current VAT framework in the UK includes the VAT Act and secondary legislation, and those implement the VAT directive, and then some directly applicable council regulations, EU council regulations, which will presumably be continued by virtue of the Great Repeal Bill. The Customs Bill will apparently modify elements of the VAT regime, and this is certainly needed to make the regime coherent within the UK, as the current rules are drafted on the assumption that we are an EU member, so simply don't make sense in certain contexts. I think in the interest of time, I'm going to skip this slide, which is dealing more substantively with what the VAT impacts are on separation from the EU, but I can obviously answer questions on that. So looking forward to the picture post-Brexit, it seems unlikely there's going to be a radical change to the UK VAT system. Perhaps we might include more categories of things that are zero rated and that sort of thing. But it's such a large revenue raiser that the fundamental structure of the system, it seems to me, unlikely to change. But there is a clear risk of divergence between the EU and UK systems, even if we don't have any more change domestically. So going back to the mechanics of the Great Repeal Bill, the UK VAT legislation will be pre-exit EU-derived law. So according to the rules, it should be interpreted in accordance with EU law as at the exit date. Presumably, this will mean that the UK courts should take into account the fact that the legislation is intended to implement the VAT directive. There's a question about whether that means they should simply use the directive as an aid to interpretation, or should the VAT directive as now prevail in the case of uncertainty or ambiguity or conflict? And this goes back to the question I was raising earlier about what happens where you have existing UK legislation that fails properly to implement the underlying EU law. But anyway, it's not always easy to know what the VAT directive means if you've read it. And post-exit, the UK courts may not be able to refer questions of interpretation to the Court of Justice. That's a question that's going to be up for debate with the EU. But if not, they'll have to come to their own views about what the directive and the VAT legislation is supposed to mean, based on the jurisprudence of the Court of Justice as at the exit date. So you can see the situation where the UK court decides one thing, and then the same question later comes up in another EU country and does go to the Court of Justice, which may come to a different conclusion. Another question is whether the UK courts should take account of Court of Justice decisions post-exit, where they're interpreting the same legislation. So that's where the Court of Justice decision has happened first, and the UK court, should it take it into account? It's very hard to me to imagine that the UK courts would just ignore the fact that there's been a decision. Would they treat them as persuasive in the same way perhaps as they do judgments of courts from other common law jurisdictions? Or might that depend on whether they thought the court was in fact changing, developing the law, or simply uncovering the interpretation of the VAT directive at the date of exit? Apart from all these tricky questions to do with interpretation of the courts, there's also proposals around for a reform of the EU VAT system, which could very clearly result in differences developing between the two systems. The consequence for business is increased cost and complexity, which Janine will be touching on. Another possibly less visible way in which EU law has affected UK tax rules is through the application by the Court of Justice of the fundamental freedoms of the EU Treaty. There are a number of cases where the Court has decided that national tax rules are contrary to the treaty if they treat EU established businesses or individuals differently from those established domestically. And the UK has had in the past to change its rules in a number of areas to comply with these rulings, and if they haven't been changed or haven't been changed enough, the UK courts have to apply a conforming interpretation, which may in some cases mean disapplying the relevant rules altogether. So this is a classic example of where parliamentary sovereignty has been affected within the EU in a way that probably wasn't wholly expected by those who originally signed the treaty, especially that direct taxes were supposed to remain a sole competency of member states. So a big question is whether, as we leave the EU, our domestic law will remain subject to these fundamental freedoms to any degree. And this would seem to depend on whether they're treated as pre-exit EU-derived law by reason of the Great Repeal Bill. The principle of continuity, which is set out in the first quote there from the White Paper, suggests that these sorts of treaty rights should continue to apply in interpreting pre-exit law. And it's expressly stated in the White Paper that at least some of the treaty rights are intended to remain applicable. But the language used is slightly odd, because it refers only to incorporating into domestic law the rights and treaties that can be relied on directly by individuals. And it's not clear whether this is a deliberate framing of this and means that a corporate taxpayer couldn't seek to apply them or not. My own assumption has been that this is perhaps an accident of drafting, given that the concrete examples in the White Paper are things like employment rights, which will only be generally relevant to individuals. But on the other hand, EU cases in this area have been quite expensive for the government in terms of repayments of tax, so one can't rule out altogether the possibility that it could be deliberate. So assuming the fundamental freedoms will be incorporated as pre-exit EU-derived law, then you have the possibility that a taxpayer might bring a challenge against the validity of domestic UK tax rules on EU grounds, even after we've left. So, for example, if it wanted to argue the dilutions that have been made to some of the anti-avoidance rules don't go far enough in the EU context. So, first question would, if they brought such a claim, which court would hear it? The EU's negotiating guidelines and their position paper published yesterday that suggests that they want there to be a right to bring cases to the Court of Justice for pre-exit breaches of EU law. So perhaps such a case would end up in Europe. But if not, then it would have to be brought in the UK courts. Taxpayers' argument would be there's a conflict between the fundamental freedoms, pre-exit EU-derived law, and the UK tax rules, which are pre-exit non-EU-derived law. The Great Repeal Bill tells us the fundamental freedoms would prevail. So for the UK court, it has to decide, well, is there a conflict? That depends in part on the interpretation of what's required by the fundamental freedoms. The court would have to apply the case law of the Court of Justice as at the exit date. But probably, if this is happening, there won't have been any case law directly on point. So it'll be left to its own judgment. And while the Court of Justice has been quite expansionist and integrationist in its interpretation of the fundamental freedoms, would a UK court necessarily, if deciding the point itself, come to the same conclusion? What cognizance will the UK court take of a case that's been decided of the Court of Justice, by the Court of Justice in the post-exit period? Again, will they treat it as persuasive? And another tricky question is whether the claim can only be brought in respect of the pre-exit period, or could you even bring it in relation to a post-exit period if the underlying law hasn't been changed or reenacted? In that case, the effect of EU principles on domestic law could have a very long tail indeed. Now, this final slide is a bit of a conundrum, which I think maybe might be a conundrum too far, so to give Janine time to speak to her topic. So I'm going to finish there and happy again to talk about that to anybody afterwards. Thank you.